Hello, my name is Greg Hansch. I work as Public Policy Director for the Texas affiliate of the National Alliance on Mental Illness, also known as NAMI Texas. Let me tell you a little bit about NAMI Texas before we get started. Our purpose is to help improve the quality of life for individuals affected by mental illness through education, support, and advocacy. I want to thank your professor for inviting me to talk about a few key sections of the Texas Mental Health Code. What we are referring to here are state laws that deal with the treatment of individuals with mental illness. These laws have a major impact on outcomes for this population. They also guide the practice of nursing in mental health treatment settings, so I encourage you to familiarize yourself with them. If you have any questions, please feel free to reach out to me. Okay, let's get started. The purpose of the Mental Health Code is to provide each person having severe mental illness with access to humane care and treatment. It aims to do this in 8 different ways. 1. By facilitating treatment in an appropriate setting. 2. By enabling the person to obtain necessary evaluation, care, treatment, and rehabilitation with the least possible trouble, expense, and embarrassment to the person and the person's family. 3. By eliminating, if requested, the traumatic effect on the person's mental health of public trial and criminal-like procedures. 4. By protecting the person's right to a judicial determination of the person's need for involuntary treatment. 5. By defining the criteria the state must meet in order to order involuntary care and treatment. 6. By establishing the procedures to obtain facts, carry out examinations, and make prompt and fair decisions. 7. By safeguarding the person's legal rights so as to advance and not impede the therapeutic and protective purposes of involuntary care. And 8. By safeguarding the rights of the person who voluntarily requests inpatient care. Let's go over a few definitions before we move forward. When we refer to inpatient care, that means treatment in a hospital. Outpatient care means treatment in the community. The Mental Health Code has a number of provisions that apply to both inpatient care and outpatient care. Most of the provisions also apply to both public and private hospitals and to both psychiatric hospitals as well as general hospitals. So it's very likely that in the course of your career, you will interact with these laws and you'll be responsible for implementing them. Our first topic will be voluntary admissions. For people who are 16 or older, they may request admission to a facility. They do not need their parents' consent in order to do so. For people who are younger than 18, their parent, guardian, or legal conservator may request admission for the young person. However, guardians or conservators may only request admission if the person consents. If the person does not consent, the person may be admitted for inpatient services only upon application for court-ordered mental health services or emergency detention or an order for protective custody. Those are all concepts that we'll get into a little bit later in the presentation. For a person who is 16 or 17 years old, an inpatient facility may admit the person if the person's parent, managing conservator, or guardian consents to the admission of services, even if the person does not consent to the treatment themselves. The determination for whether or not to admit the person is made based on 3 criteria. 1, if an examination reveals that the person has a mental illness and would benefit from services. 2, if the person has been informed of his or her rights as a voluntary patient. And 3, that the voluntary admission has been agreed to by all parties. The intake, assessment, and admission entail the following components: a review of the prospective patient's finances and insurance benefits, an explanation to the prospective patient of his or her rights, and an assessment that must be provided by a professional who meets Department of State Health Services rules. RNs do meet Department of State Health Services rules, and those rules state that an RN shall conduct and complete an initial comprehensive nursing assessment of a patient within 8 hours of the patient's admission. The rules also state that an RN shall reassess a patient based on the patient's needs at least every 12 hours after the initial comprehensive nursing assessment. The rules state that 8 hours of in-service training are required before a person may conduct intakes and assessments. Before a prospective patient is voluntarily accepted for treatment, there has to be a physician's order admitting the person. The physician has to conduct a physical and psychiatric evaluation within 72 hours of the admission, and a facility administrator has to agree to accept the person. Persons who are voluntarily admitted have certain rights, including but not limited to the following. Voluntary admission does not affect that person's civil rights or legal capacity. It does not affect their right to obtain a writ of habeas corpus, which allows them to appear before the court for a hearing. It does not affect the person's right to information on medications. The person has the right to be reviewed periodically to determine his or her need for inpatient treatment. The person has the right from court-ordered services unless either a request for release from the facility has been filed or the patient is absent from the facility without authorization, or the person refuses to consent or can't consent to necessary and appropriate treatment. And the person has the right to be appropriately informed of his or her rights. Discharges for voluntary treatment must be filed in writing, and within 4 hours of receiving the written request, the facility administrator must notify the treating physician. The physician must discharge the person within that 4-hour window unless the physician has reasonable cause to believe that the person might meet the criteria for court-ordered mental health services or emergency detention. If the physician does have reasonable cause to believe that, then they have to evaluate the person within 24 hours, and if the person makes the determination that the person does meet that criteria, by 4 p.m. the next day, they must either discharge the person or file an application for emergency services or detention. There are some exceptions to those rules in cases of extreme weather or hazardous conditions, but those are generally the rules that apply. So that kind of sums it up for voluntary admissions. Most of the mental health code is centered around not voluntary admissions, but involuntary admissions to a treatment facility. And as we'll discuss, there are reasons why there has to be a procedure in place for when a person needs treatment but does not necessarily voluntarily accept that treatment. One key definition here is a civil commitment. Civil commitments are the legal process through which an individual with symptoms of severe mental illness is court-ordered into treatment. These contrast from forensic commitments, which are commitments to treatment facilities that arise from the criminal justice system, and that will be another topic for this presentation. Civil commitments often begin with what's called an emergency detention. Emergency detentions allow for a person to be brought to an inpatient mental health facility and held if it is believed that a person is a serious risk of harm to themselves or others if he or she is not immediately restrained. Emergency detentions may be initiated by police officers, guardians, or judges. A person accepted for preliminary examination under an emergency detention may be detained in custody for not longer than 48 hours unless an order for protective custody is filed. The 48 hours includes any time spent waiting for medical care before the preliminary examination. A physician is required to examine the person as soon as possible within 12 hours after the time the person was initially apprehended or transported. In order to continue to hold the person, the preliminary examination has to show that the person has a mental illness, is a risk of harm to self or others, and the risk of harm is imminent unless the person is immediately restrained, and the emergency detention has to be shown to be the least restrictive means to accomplish the necessary restraint. Typically, if a person is held under emergency detention and the need for continued restraint is observed and the 48 hours are up, then an order for protective custody can be filed. This may only be filed by a district or county attorney. There is similar criteria as what is used for emergency detention, that a person is believed to be a serious risk of harm to self or others, and that the risk is substantial unless the person is not immediately restrained. After the filing for an order for protective custody, a probable cause hearing has to be held within 72 hours. All of these procedures can only last for 2 weeks. So emergency detentions, orders for protective custody, those are not going to last any longer than 2 weeks. If the government wants to continue to hold the person, a hearing for temporary or extended court-ordered mental health services must be held within 2 weeks of the initial filing. So when we talk about civil commitments, we're really referring to court-ordered mental health services, either on a temporary or extended basis. Here are the basics of civil commitments. A person may be court-ordered by a judge to receive temporary inpatient mental health services not to exceed 90 days if it is found that the following 2 conditions are met: that the person has a mental illness and that the person is likely to cause serious harm to the self, that the person is likely to cause serious harm to others, or that the person is suffering from severe and abnormal distress, is experiencing substantial deterioration of the ability to function independently, and is unable to make a rational and informed decision as to whether or not to submit to treatment. So there are 3 criteria that can be utilized to civilly commit a person. A judge may not issue an order for temporary inpatient mental health services if the person is charged with a criminal offense that involves an act, attempt, or threat of serious bodily harm to another person. A person may be court-ordered by a judge to receive extended inpatient mental health services or more than 90 days if it is found that the condition is expected to last more than 90 days, and if the person has received court-ordered inpatient mental health services or competency restoration services, which we'll get into, for at least 60 consecutive days during the preceding year. If it is found that the person does meet the criteria for either temporary or extended mental health services, the judge will have the person committed to a designated inpatient mental health facility. It is then that facility's responsibility to provide for the treatment, well-being, safety, and care of the individual throughout the duration of the court order. Part of that responsibility relates to the practices that are used in the hospital. When a person is in psychological crisis, it is common for hospitals to want to prevent the individual from inflicting any physical injury to the self or to others. Restraint and seclusion are 2 techniques that are used. It's important for practitioners to understand what is and what isn't allowed for in this regard. Restraint and seclusion practices are spelled out in Chapter 322 of the Texas Health and Safety Code, a component of the Mental Health Code. And there are also some rules in the Administrative Code that relate to restraint and seclusion, and I'll talk a little bit about those as well. But first, let's define what we mean by restraint and seclusion. Restraint is the use of any personal restraint or mechanical restraint that immobilizes or reduces the ability of the individual to move his or her arms, legs, body, or head freely. Seclusion is the involuntary separation of a resident from other residents and the placement of the resident alone in an area from which the resident is prevented from leaving. It's separating the individual from the rest of the population. There are general requirements under the law that less restrictive interventions be used first, that interventions are safe and effective, and that only trained staff are implementing them. A person may not administer to a resident of a facility a restraint that obstructs the resident's airway, including a procedure that places in, on, or over the resident's mouth or nose. They also may not implement a restraint that impairs the resident's breathing by putting pressure on the torso. And also, it's prohibited to implement a restraint that interferes with a resident's ability to communicate. The Texas Health and Safety Code states that a person may use a prone, face-down restraint or supine hold on a resident of a facility only if the person uses the hold as a last resort when other less restrictive interventions have proven to be ineffective, or B, uses the hold only when an observer who is trained to identify the risks associated with that hold and who is not involved with the restraint itself, only when that person is present. You'll see that in the administrative code, there is a more flat kind of prohibition on prone and supine restraints. And it's really important to be very careful about implementing these restraints because it seems to me to be pretty clear under the administrative code that these restraints are not allowed when used on a person. The administrative code states that providers may not use holds that restrict circulation, that secure an individual to a stationary object while the individual is in a standing position. Restraints that cause pain may not be used, and restraints that inhibit, reduce, or hinder an individual's ability to communicate may not be used, as well as chemical restraints are prohibited. Now, kind of on to a different topic that relate to when an individual with mental illness becomes involved in the criminal justice system. It's pretty common for this to happen. Although cases involving the insanity defense often grab the headlines, they are actually relatively rare. By way of contrast, competency issues arise in Texas courthouses every day of the year. Under our legal system, a criminal defendant may not be put on trial if he or she does not understand the proceedings being conducted against him or her. If the person is not in an ability to communicate with or assist his or her legal counsel, the criminal proceedings may not move forward. Many years ago, a former version of the Texas law on competency to stand trial focused on whether the defendant suffered from present insanity at the time of the trial. Although no longer part of the law, this antiquated phrase is useful in understanding that the question of competency relates to a criminal defendant's mental state, not at the time of the events resulting in the criminal charges, but at the time of the trial. Unlike the insanity defense, which we'll discuss in a little while, a finding of incompetency to stand trial is not a defense to the crime charged. In other words, a determination of incompetency does not serve to excuse the offense. Instead, it relates to whether the defendant has the present capacity to stand trial at that time. This incompetency to stand trial applies to a defendant charged with a felony or misdemeanor punishable by confinement. Other misdemeanor offenses in which fines are the only applicable punishment are excluded. Again, the term forensic applies to persons acquitted not guilty by reason of insanity or found incompetent to stand trial. The issue of competency may be raised by the prosecuting attorney, by the defense attorney, or by the court on its own motion. After the issue of competency is raised, the court conducts an informal inquiry, and if the court finds that there is no evidence of incompetency, the criminal proceedings resume. If the court finds that there is evidence of incompetency, the court orders an examination by a psychiatrist or a psychologist. It is then that person's job to give an opinion as to competency or incompetency to stand trial. This psychiatrist is looking at if the defendant has a rational understanding of charges, an understanding of potential consequences of criminal proceedings, an ability to understand the adversarial nature of proceedings, and an ability to work with counsel about important facts, events, legal strategies, and options, an ability to behave appropriately in the courtroom, and an ability to testify if needed. They are also, of course, looking at if the defendant has a diagnosable mental illness or intellectual or developmental disability. If the person does have one of those conditions, it is looked at the degree of impairment and if the defendant is taking a psychoactive or other medication. The report of that examiner is due within 30 days of the order for an evaluation. It is then the job of the judge or jury to make a ruling on competency or the lack thereof. So a competency hearing is held. If a person is found incompetent to stand trial, then the person must be restored to competency before any sort of legal proceedings can continue. Individuals determined to be incompetent may be placed in inpatient psychiatric facilities or outpatient programs or even jail-based competency restoration programs. Competency restoration in the criminal justice system is the process that is used when people with mental illness or intellectual disabilities are charged with crimes but are deemed incompetent to stand trial because they lack the capacity to participate in their own defense. So when that determination of incompetent to stand trial is made, the determination about where to place the person is made based on a few factors. If it's high clinical complexity of the individual's situation, they're typically placed in a state psychiatric hospital. If it's low clinical complexity but a high security risk, they're placed in a jail-based restoration program. And if it's low clinical complexity and low security risk, they're placed in an outpatient competency restoration program. If a person is committed to an inpatient competency restoration program, the length of stay is up to 60 days for a misdemeanor and up to 120 days for a felony. An extension of 60 days can be allowed for. If the person is committed to an outpatient competency restoration program, the length of stay is up to 120 days. The treatment team in those facilities or in those programs is responsible for developing an individual treatment plan. They're responsible for assessing whether competency is attainable in the foreseeable future, and they're required to report to the court and to the local mental health authority on the progress that is made towards competency. Competency restoration services include the definitions of important persons in the courtroom, such as the judge and the attorneys, the definitions of important legal terms, the instructions on how to behave in the courtroom, instructions on how to work effectively with counsel, information about court-ordered medications, information about rights as a forensic patient, and an explanation of criminal charges and potential consequences. So you have to remember, if you're working in one of these settings, either inpatient or outpatient settings, the job of the treatment staff is to provide those services which relate to the criminal justice process. So it's not really what you would typically think of as being a medical service, and yet that is the responsibility of the medical providers in these settings for competency restoration. When the competency is attained, it's the responsibility of the head of the facility to notify the court. If they find that competency is not achievable in the foreseeable future, it's common for the criminal charges to be dropped and for civil commitment proceedings to proceed. That's kind of the main gist of competency restoration and the incompetent to stand trial procedures. Now for insanity defense. The insanity defense is an affirmative defense. That means that if the defendant and his or her representation proves a set of facts other than what is being presented by the prosecutor, the legal consequences of a certain act can be defeated. A person can be found not guilty by reason of insanity. There are a lot of cases like these in the media. You may remember the Andrea Yates case being something that occurred here in Texas, and Andrea Yates was committed to a state hospital because she was found not guilty by reason of insanity. So the insanity defense is an affirmative defense to prosecution that at the time of the conduct charged, the defendant, as a result of a severe mental disease or defect, did not know that his or her conduct was legally or morally wrong. That's how the state of Texas defines the insanity defense, and it's different from the way that other states define it. The term mental disease or defect does not include an abnormality manifested only by repeat criminal or otherwise antisocial conduct. So those types of behaviors do not necessarily equate to mental disease or defect. The issue of insanity defense, unlike with incompetence to stand trial, is only raised by the attorney for the defendant. The attorney for the defendant must file with the court a notice of intent to offer evidence of the insanity defense at least 20 days before the date the case is set for trial. No trial is needed if all parties agree to the dismissal of the indictment on the ground that the defendant was insane. A juror or prospective juror may not be informed of the consequences to the defendant if a verdict of not guilty by reason of insanity is returned. It is simply a juror's job to determine whether or not the person is guilty or not guilty. Much like with competency restoration, there is an examination if the insanity defense is raised. Again, a qualified psychiatrist or psychologist provides the examination. The same expert may be appointed to examine the defendant with regard to his or her competency to stand trial. So both that same individual can be making the evaluation for competency or for insanity defense. The expert may not examine the defendant for purposes of determining his or her sanity if it's in the expert's opinion that the individual is incompetent to stand trial. So the incompetent to stand trial determination comes before the determination of whether a person is sane or insane. The report from that professional is due within 30 days of order of the evaluation, and if a person is found not guilty by reason of insanity, they are acquitted of the offense charged, meaning they are found not guilty, and they may not be considered a person charged with an offense. Immediately following a not guilty by reason of insanity verdict, the court must determine whether the offense of which the person was acquitted involved conduct that caused serious bodily harm to another individual. And if the court determines that a person is in imminent danger of serious bodily harm or serious bodily injury, then the person is committed for evaluation of present mental condition and treatment to a maximum security unit for a period not to exceed 30 days. And then the court must have a hearing on disposition not later than the 30th day of acquittal. The court shall commit a person to inpatient or residential care if it is found that the person has a severe mental illness or intellectual or developmental disability, and that as a result, he or she is likely to cause serious bodily injury to another if not treated and supervised, and that residential inpatient care is needed to protect the public. The order of that commitment expires on the 181st day following the date that the order is issued. The court determines annually whether to renew the order. This requires evidence that continued mandatory supervision and treatment are appropriate, and renewed orders are for no more than 1 year. So they're evaluating these orders annually. And orders may be modified to outpatient. That, I believe, is what happened with Andrea Yates. She's no longer held in Kerrville State Hospital, but she is serving her commitment on an outpatient basis. And it's the job of the settings where people are committed to provide for the treatment, safety, and care of the individual. That was all for if a person is found to be dangerous. If a person is found to be not dangerous, then the case is transferred to civil court for the civil commitment proceedings that we talked about earlier. So that covers our topics. We discussed restraint and seclusion. We discussed civil commitments, forensic commitments, and I hope that gives you a better understanding of how these procedures work in our healthcare and criminal justice systems. I appreciate you listening to this presentation, and I hope that you'll reach out to me if you have any questions. You can reach me at my email address, publicpolicy.director@namitexas.org, or by phone at 512-693-2000. Thank you again.